I am Lucy Gimbel. I'm the compliance broker at Keller Williams Hilltop. I have been in real estate for a really long time. I don't sell. I like the contracts. I like the black and white and knowing what needs to be said and how it needs to be said to get things the way they need to be done and kept legal for the process. So we're going to start today with purchase contracts. The beginning of the purchase adventure starts with your buyer consultation. Your buyer consultation should take place before you put the buyers in your car and go shopping, or before you meet them at a property. Virginia law says whenever you have substantive conversation regarding real estate, that's the time you need to enter into a brokerage relationship. So there may be times, especially this day and age, where you're not necessarily meeting up before you go to the first property. You've only had talks on the phone or via video chat or whatever may be. And you may finally physically come into contact with the people at the property for the first time. And go ahead and show them that one property, but don't show them more than the one before you get all of this filled out. It protects you, it protects them, and it sets the expectation for how things are going to go. So this checklist, you're going to have your buyer broker agreement or an unrepresented party agreement to start out with. And the reason this is important is because in Virginia, we still have a very old law on the books that states that all the agents represent the seller in a sub-agent sort of capacity. So if you think of a construction site and you've got the builder who has the great big conglomerate that's doing the whole building, he then subcontracts out to plumbers, electricians, and the like to get the smaller things done. Well, that umbrella is the same in real estate, where everybody represents the seller because the seller's got the listing. But then you would come in with your buyer as a sub-agent of the seller, where the buyer is still left completely unrepresented. And now you're putting the seller's representation at risk as well. So instead of changing the law, we have now got exclusive representation for the buyer to protect them. So now the buyer has their representation and the seller has their representation. And we'll talk about the weirdness of the unrepresented party agreement when we get to that form. So we're going to start with the exclusive right to represent buyers. This particular form has been developed by our attorneys for our office. There are other general forms you may see. There's a Virginia Association of Realtors form, and other companies have their own forms. But this is the one we're using for our office, and all of your buyers who are represented need to have this filled out and signed. So you're going to start the date on the meeting that you have with the client, and you're going to enter the buyer's names in this blank. Oh, let me back up a minute and say, I am not going to read all these documents to you. We'd be here for weeks if I read everything and we discussed every sentence. What we're going to do is I'm going to tell you the best practices for filling them out. You can ask questions if you have questions about how we're filling it out, but it's going to be up to you to go ahead and do all the reading of the documents. If during your reading you have questions, jot them down. Call, email, or text me and let me know. If you have questions, we'll go over them individually, but the reading of the actual documents and the making sure you understand it, it's going to be on you. I'll help you get them filled out properly and legally. Okay. Oh, let me check. I got some chat stuff going here. Let me see what we got. Donnie, date of meeting or date of first showing? Well, it depends on what you're doing. If you're meeting them before you're going showing, that's when you're going to put that date in there. If you are meeting them at the first showing, that's going to be the date. It is going to be the date upon which you have substantive conversations regarding a real estate transaction with that person. Does that make sense? Got it. Okay. So that's the date, buyer's names. The term of the agreement typically goes 3 to 6 months. You may have a different scenario, especially in a military community like we are, where the buyers are going to be 6 to 9 months or maybe even a year out. However, doing a whole lot of looking during that time
kind of add like
probably not going to be real beneficial. Let me see, we've got some noise here. Let me see if I can mute. Can everybody please make sure you're muted unless you have a question? Thank you. So the timeline is usually 3 to 6 months. You know, buyers usually aren't itching to look for a year. You may have exceptions to that rule, but that's the typical time. So you're going to put an actual calendar date on here. So if you met with them the beginning of August to start their look, you're going to put August 1st. And maybe you're going to go through the end of November because they said if they can't be in a house for Christmas, they're going to stop looking until after the first of the year. So you go ahead and put November 30th as your end date and pick things up later. Now, if you put somebody under a 3-month term, you can always line this out, change the date, and have everybody initial it. You don't have to do a whole new form. So unless the form itself changes. So you can easily amend that date as necessary. No, there's no penalty for going over the 6 months. This is between you and the buyer. So whatever you and the buyer agree to as your term of relationship, that's fine. There's no problem. And then your buyers are going to initial at the bottom of the page. More reading on page 2, pretty much just read all of it and then have buyer initial at the bottom of the page. Note here is the $395 administrative fee. It's already in there for you. And again, reading. We do not do dual representation at Keller Williams. Designated representation is how we work. We do not do dual representation. So that's not something you have to worry about. Initials at the bottom of the page. On this page, your buyer needs to check one or the other. They either are a licensed agent or are not a licensed agent. If they are a licensed agent, please enter the licensed name on this line so we have a record of that. And then remember that you're going to have to disclose that within the body of the contract. Initials at the bottom of the page. And then everybody's information and signatures. Okay. And initials again at the bottom of the page. That is the buyer broker agreement. Any questions that we haven't covered? All righty. Let's see here. There we go. The next is going to be the unrepresented party form. Oh, that took up a lot of page. That's fine. I'm answering questions here. What if they're agents in another state? Yes, it's better to disclose that than not, because they have a different advantage. I don't want to say unfair, but they have a different advantage that the seller needs to be made aware of. Seller needs to be aware that these people are a little more savvy in the home purchasing process, and there may be some things that this buyer is going to want that the seller is not quite expecting. So yes, it's always better to disclose than not, always. All right, this is our multitude of pages of all the things that, oh no, I'm sorry, this is the brokerage relationship to the unrepresented party. So if your buyer says, I don't want you to represent me. I'm not comfortable with that. Well, you can't represent the seller because the listing agent has an exclusive representation with the seller. So in that case, what you have to do is have them fill this out. You're going to put their names here, the property address if applicable. You can have it pertain to a single property. You don't have to have it last a long time. So if they say, I'll work with you for this one property, you can do that on the buyer broker agreement, or you can do it on this agreement. Our agency, and then you put your name on this line. So it's the firm and the licensee. If you're not representing the seller and you're not representing the buyer, you're going to have to create your own little checkbox and check none. You are not doing anything more than ministerial tasks for that buyer. You may write a contract, you may submit a contract, but you're not going to do a CMA. You're not going to negotiate for them. You're not going to do all of those things that you're going to do for a represented buyer. You're going to fill out the paperwork and you're going to give it to the other side, and you're going to step back and wait for the response. You'll present the response to the buyer and say, what would you like to do now? That's where that all ends. Whereas when you represent a buyer, you're going to do the CMA. You're going to say, well, this is what the price in the neighborhood is looking like. So this is where I feel an appraisal might come in. So we're comfortable with this price. What price do you think within this range? You're going to do a whole lot more research and advising for a represented buyer. Okay. And this is what's going to be signed instead of that representation.
Why would you do this and not represent them?
You don't want to. I mean, there are buyers who have had issues with real estate transactions in the past. Maybe they don't know you well enough to feel confident in your ability, and they don't want to be locked into a 90-day contract with you. It's not the best scenario for any of it, for sure. But it defines the relationship and it sets the expectation. You need to let them know if they do choose to sign this and not have you represent them, you're the admin. All you're doing is the paperwork. You're not going to advise them. You're not going to negotiate for them. You're not going to fully represent them.
Yeah,
okay?
So I guess Letitia's asking too, like, so why would I want to help them if they don't want me to represent them? Wouldn't I want to just refer them to somebody else?
You can still get a commission with an unrepresented buyer. You're not out of commission, but there is nothing that keeps that buyer loyal to you. They can be having you search properties, and investors do this an awful lot. They can be having you search for properties. They can have somebody else search for properties, and whoever comes with the most.
Oh, so this is ideal for investors. Okay.
This is ideal for investors who want to shop around and don't want to be tied to any given agent. They don't care who gets them the property. Whoever comes with the best property first wins. So that depends on whether you want to spend your time spinning your wheels with people who aren't going to be loyal to you. It's your business decision. I personally wouldn't do it on a regular basis. Now, the other time this is going to come into play is if your buyer finds a for sale by owner that they absolutely have to have. Mm-hmm. In that case, you're going to fill this out such that you're notifying the seller that they are unrepresented and you fully represent the buyer.
Oh, okay.
Okay. So there have been more of that, especially in this market when owners are more confident in their ability to sell by themselves. So in that case, you would put the seller's name here. If the seller is the for sale by owner, because they are going to be unrepresented, you already have your buyer under a buyer brokerage agreement. Then you put the property address and you state that Keller Williams and your name represent the buyer. And you're making that very clear. You represent the buyer, then you have the sellers sign it and you sign it. And the same thing happens. You advise the buyer, you negotiate on the buyer's behalf, you make sure the buyer's got the best possible scenario for their purchase. And for the seller, you help facilitate paperwork. That is it.
Is possible in this case, in that case, that I show a property to my client, to my investor, and he decides to buy the property, same property with another agent. Is that possible?
If they are under an unrepresented party, that's fine. You have no relationship.
Nice.
Yeah. So if your investor looks at this property and says, okay, I want to write a contract, and you say, I've got appointments till 5 o'clock, I'll get with you after that. And at 3:30, they find another agent who can write the offer right then. Well, you can try and fight for procuring cause, but you're probably not going to win because they don't have a brokerage relationship.
Okay, I got it. Very risky, right? Yeah.
Very risky. It could be a very big drain on your time and energy.
Yeah.
Okay. If you have particular scenarios, we can go over them individually. So next on our list is our consumer disclosure information form. This is the 7 pages of doom and gloom that Rain wants us to put out there for all consumers. All the things that could go wrong, might go wrong, could happen, all of the different things. So this needs to be looked at, just talks about our agency interest disclosures, the potential for audio and video recording at a property, POAs, condos, disputes. Every page of this has to be initialed by the client, but in this case, in the buyer. We're talking about buyers today. So you need to get familiar with this so that you can explain it to your clients and have each page initialed by the clients.
I have a question.
Yes.
What if there is a contract, a ratified contract, and the agent passed away? Who's going to be responsible to close that?
Whoever the brokerage assigns to the deal.
Okay.
Remember that everything, you may represent the client as an agent, but you only represent the client as an agent of the brokerage. That client belongs to Keller Williams. You are just working with them on behalf of Keller Williams.
Okay, makes sense.
So Keller Williams will then assign another agent to take care of that transaction.
Okay.
So, like I said, 7 pages of fun reading. I want you to sit down, take some time. Even if you do it one document at a time, you need to read through them and make sure you understand them so you can explain them to your clients. And then you're going to fill in all the information and everybody's going to sign it. Okay. Along with that is our Chapter 7, Summary of Rights and Obligations. Let me check the chat here before we go on. Okay, I think we're good. We've talked about the unrepresented. So this is just another 3 pages of additional items that the consumer needs to be aware of in this area. Each page, again, needs to be initialed. This one only requires the consumer's disclose to sign it. You don't have to sign it as well. But both the CDIF and the Chapter 7 are listed in the purchase agreement as having been provided to the buyer by the brokerage. So you have to make sure you get those done and signed. Next is our cybersecurity notice. This is to notify everyone that there are nefarious beings out there who are trying to get in the middle of transactions and steal money. It happens every day all over the world. Your clients need to know to be vigilant and careful and always safeguard their money. So this just explains some of that. And if they have any questions, feel free to call and ask. Signatures on that. And then we have our escrow agency notice. This is because Keller Williams does not hold earnest money. Only the escrow agent will hold earnest money. Therefore, you need to have a company name, a contact, and a phone number that the buyer will be using for their escrow and for their settlement. Jones, Walker, and Lake is our preferred attorney, and they're already all set to handle all of these things. Again, because we have our relationship with Jones, Walker, and Lake, they are also Tomahawk Title. We need to notify all consumers that we have a business arrangement with this company. This does not obligate the buyer to use Jones, Walker, and Lake and/or Tomahawk Title, but we have to notify them that we have a relationship, and that is stated here. You know, they've read the disclosure, understand that we're referring them to purchase the services, and that we may receive a benefit as a result, but there is absolutely no obligation. No obligation. See here, you are not required to use Tomahawk Title as a condition of your closing on the subject property. We just are required by law to notify every consumer that we have this arrangement with them and that they are aware of it. Check in the chat, hang on. Hanger law, sure, you can use hanger law. We don't have an arrangement with them, so we don't need to use the disclosure, but you would put hanger law then in the escrow agency notice in this information. Anybody you and your buyers want to use to close, great.
So if we use anybody else for closing, if the client wants somebody else, then we don't include the disclosure.
You
It's
do
only
not need
when
to
we
use,
are using.
you do not
Walker
need
and
to
Lake.
use this disclosure. No, I'm
Okay.
sorry, everybody does have to sign this because we have to notify everyone that we have this relationship. So whether
So
they,
everybody gets it, no matter who the closing title
correct,
company is.
correct.
Okay.
Whoever is doing the closing it doesn't matter. This has to be filled out and signed simply because we have to disclose by law that we have this arrangement and this relationship. Okay.
Thank you.
And then this is a big hang up for a lot, but because you are meeting, you're supposed to be meeting and discussing all this before you go shopping. So this EPA-led booklet needs to be provided to the buyer regardless of what they purchase. A lot of times after the fact, I get agents coming back and say, but Lucy, they bought a house that was built in 2000. I get that. And therefore you don't need the lead-based paint disclosure with your purchase agreement. However, we need to provide this information to a buyer because we don't know when we meet them where they're going to end up purchasing and what the age of the property might be.
Okay.
So I want this provided to every buyer, and I want it initialed or signed somewhere on this document that they have seen it and received it. It is in broker mint for you. Okay? Because you're supposed to be having these discussions before you go shopping. And you should have a copy of a pre-approval letter before you take them out searching for a property. If you don't know what they qualify for and they can't show you what they're able to purchase, this is going to be a really frustrating time for everybody because they're going to fall in love with the house that they can't afford. And that's just not going to be good for anybody. Okay. So that is all of our buyer consultation. All that should be done before you go shopping. If they ask what is the arrangement, I don't know what the arrangement is. I can't tell you what the arrangement is. It just means that Jones, Walker, and Lake may support us with a party, a advertising dollars. I'm not sure. I do not know what our arrangement is, but we do have an arrangement with them. That's all I can tell you. I am not privy to what's behind the curtain. All right. So now we're going to go over our purchase documents. You're going to want a copy of the city tax record and a copy of the MLS printout when you, at the time you show the property. And again, your lender pre-approval letter. Okay. So we're going to put together our purchase agreement. We've been shopping. We've got all the things. We know what price we're going to do. And here's how we're going to fill in our purchase agreement. The date you write the offer is at the top. You're going to put the full legal names of the buyers on line 2, because the attorney or title company is going to use this information to create the title for the buyers. So you really do want to make sure you're not putting Billy Smith when his name is William John Smith Jr. You really want his full legal name. I typically suggest that you put whatever name is on their driver's license on this line. Seller, you're going to get from the realist tax report. I would recommend taking it from the tax report over the MLS, because the MLS is only as good as what the agent puts in. Okay. Then we are Keller Williams Realty, firm 9274. The listing firm is going to be on the MLS sheet, as is their office number. Property description, you're going to get the legal description from the realist tax report. And then you're going to put the full address, the street, the city, the state, and the zip code. All of the information. Because again, this is what the lender and the attorney or title company are going to use to start their searches for title and that sort of thing. Your earnest money deposit, you're going to start with the number written out in words, for instance, $1,000, and then you're going to write it numerically with numbers, 1000. You can use the legal description from RAIN. I think it's auto-populated from the tax record. However, the tax record is going to be more accurate. I'm giving you the best scenario for making sure you're not going to have to write amendments, changing and fixing things. So my recommendation is to use the realist tax report, because that is what is actually on record with the city. You're going to say, has the buyer paid? Who collects the earnest money deposit? That's your escrow agent. The earnest money deposit goes to your escrow agent. That's why you have them fill out that escrow agent form. The buyer either has paid the deposit to the escrow agent or will pay within 2 business days of your ratification date. There may be a time where a buyer, especially in this market, has put an escrow down and we have not been able to close the contract. They either canceled because of HOA docs or home inspection, and they opted to have the money stay with the escrow agent for a subsequent purchase. That's when they would already have paid the deposit to the escrow agent. Or again, they will pay it within 2 days of the ratification of the contract. Purchase price.
So just to be sure, so if the contract was ratified yesterday, the 2 days would be today or tomorrow? It would mean tomorrow, right?
The ratification date is day 0. So you count
Yeah.
forward from there. So today would be day 1, tomorrow would be day 2.
Okay, great.
If you ratify at 4 o'clock on Friday afternoon, well, Saturday is not a business day, Sunday is not a business day. So you've got Monday is your day 1 and Tuesday is your day 2.
Oh, okay.
Okay.
Thanks.
Your purchase price in numbers here, it's the opposite of what your escrow is. Numbers here, written out here. I do not want to see TBD as required by lender or any other kind of verbiage here. I want numbers. Specific amounts from the lender. I understand that negotiations sometimes make this a hot mess, and you may not change these in the middle of the negotiations. By the end of the negotiations, though, this area should match the final price in this area before it's ratified, so that everybody's clear on what this is going to be. So here's your down payment. We're going to go with, this is an 80-20 loan. So it's $20,000 down and an $80,000 loan. Then you're going to state what kind of loan. Is it an FHA, a VA, or a conventional? You're only going to list one of those. If it's not a loan, if it's a cash or a hard money lender, that's what you're going to put here. In the case of cash, you may not have a down payment. You may have the full $100,000 here by cash. Okay. Ratification.
Can you hear me?
Yes, go ahead.
Let's say we have a ratified contract and for whatever reason through the process, the purchase price change. So I have to write an addendum because I cannot touch the contract anymore.
Correct.
Right? Okay.
Correct. Once the contract is ratified, it's signed in blood and stone and should not be changed. You need an amendment, will fix all of that very easily. So if you're in the ratification seat, make sure you go back over each page of the contract. Take the extra 5 or 10 minutes to go back over it so that you can verify everything's been checked, everything's been filled in, all the changes have been initialed, and all of it's good to go so that you can avoid having to do the amendments to do the corrections, okay?
I have another question. Let's say I made a mistake and, we have a ratified contract, but, in one of the pages, we missed the initials. Do I have to add an addendum for that page? Then we missed the initial?
No, if the changes have all been made and we've just missed one initial, we'll go ahead and go back and get the initials to fulfill that.
Okay.
Good questions. Am I missing any in the chat? No, okay. And then remember, all of your timelines and dates are based on this final ratification date. Make sure you're aware of all of your deadlines. But before this is all filled out, you're going to have the buyer's initial, and we're going to go to page 2. Every single page of this contract has something to be checked or filled in, which is why it has to have initials on every page. Here's your verbiage if you are asking for settlement contribution from the seller. Seller to contribute 3% of the purchase price towards buyer's closing costs, prepaid points, funding fees, appraisal, title insurance, survey inspection fees, settlement fee, and any other costs, including debt reduction at buyer's sole discretion and approved by lender. That is the biggest blanket to cover all the things regarding closing cost contributions. That is your recommended verbiage. And then more reading. Loan application. You have to say who the buyer is going to get financing from. Well, the buyer hasn't always solidified who they really want to work with. They're still shopping the market to see where they can get the best deal. I would recommend you list 3 lenders that the buyer may be working with. Because if you list all the lenders at the beginning, then you don't have to ask for permission to change. lenders as you're going through it. You would just then need to notify the other side which lender they decided to use. Okay.
Yeah, that's interesting. Thanks.
Sorry.
I said that's an interesting point. Thanks. I didn't know that was possible.
Yeah. If you've listed, say, Navy Federal, OVM, and Atlantic Bay, and then they decide to go with Chase, you're going to have to get permission. However, they decide to go with Navy Federal and you've listed Navy Federal, you just need to then inform the other side which of the three lenders they chose. You don't have to request permission to change. Now, anytime there is a change from a loan type, say conventional to FHA or FHA to conventional, any of that kind of stuff, they're going to need to get permission because the seller has the right to know what kind of loan is going to be happening. Because there are different parameters with different loan types that could affect the transaction. So just be aware of that. And then this is an optional line here. Go ahead.
So should the client get a pre-approval from each lender
Yes.
before we even go shopping then? Okay.
Yes. Yes. That is the best practice. Okay, you want to shop all these lenders, we need to have pre-approvals from all of them, knowing that we're good to go and what price they each say you can purchase. And then buyer reserves the right to adjust the down payment or loan amount at their sole discretion without permission from the seller. That is just the down payment and loan amounts. This has nothing to do with the loan type or anything else. Okay, and initials at the bottom of the page. The only thing you have to do on this page is the intent to occupy. The buyer does or does not intend to occupy the property as their principal residence. The reason behind this is because the loan programs are different for primary residence versus a secondary or investment property. C here states that the seller has the right to transfer the property fully without having anything else binding it or any other third party having jurisdiction. If there is something that is in the listing regarding a bankruptcy or short sale, it will be in the listing. And that will be disclosed. And then you would put those exceptions on this line stating it's a short sale needing bank approval, it's a bankruptcy or divorce needing court approval. But these will be listed in the disclosure section of the MLS and also should be in the agent remarks. So it won't be a surprise. You'll know what to put. This has to do with septic systems. You're going to check the appropriate box. It is either not served by a septic system, is not subject to a waiver, is subject to a waiver, or something other. Again, all of this is listed in the MLS sheet. Settlement date. This is going to be a calendar date. You're best checking with the lender for their time frame on what closing date they can meet. You know, when you get those pre-approval letters, I always recommend you give the lender a call and say, hey, we're getting ready to go shopping. I see you've given them a pre-approval. What does your timeline look like for appraisals and financing and closing, so that I know what closing date I can realistically put in my contract. And oh, let's just contemplate that we're going to need probably 3 days for negotiations before we ratify. What does that look like? And the lender should be able to give you a date for that. Settlement date may be extended by any number of days for these purposes. Now, if you leave it blank, it defaults to 10 days. We recommend you put 5 days in there because typically a buyer's lock on their loan rate is not going to expire within a 5-day period. Any longer, you really risk the buyer losing their rate lock. Before you extend anything, always check with the lender to see what kind of a position you're putting your buyer in if you do extend that.
I have a
All that-
question.
Yes,
If the rate is already locked, how could it be affected even after the 5 days if it's already locked in?
because
to ask
those
the
rate
same.
locks have an expiration date.
Oh,
Okay.
Your rate is locked. Say I go under contract August 1st with an August 31st closing date. My loan lock then may expire on September 2nd. And if I extend past that, I have to pay a penalty to keep that rate, or I have to pay a higher rate. I get a higher rate on my loan, which then requires all new disclosures and potentially puts me out of the position of being able to afford to purchase the property.
When you put in a loan lock, how will you be able to find out how long will it take for that lock to be terminated?
Lender,
Lender, okay.
that's all lender questions. The lender has all that information. And at the time of the contract, the lender may not know. Very often there are further discussions to be had once you have a ratified contract and the lender and the buyer talk about the rates and agree to work together before that lock is put in place. So you just need to have open communication with your lenders at all times. Now, this extension of the settlement date is only for 2 reasons. One, the processing and closing of the specified loan in compliance with applicable law, which means if there was a backup in underwriting, the appraisal didn't get approved in the time they thought it was going to, we need a 3-day extension because underwriting's backed up, but the buyer has provided everything to the lender in a timely fashion and it's at no fault of the buyer that we're delayed, this would come into play. If the buyer drug their feet, didn't have their documents, didn't turn in their documents, didn't disclose things to the lender in a timely fashion, and now we're late, this does not count. You're going to need to get an amendment extending the closing with everybody agreeing to it. On the seller's side, if there are defects on the title that need to be cleared and there is a delay in that, this automatic extension comes into play. All that being said, we always recommend that even if you have this extension time in place, you go ahead and get an amendment done and signed by all parties extending the closing. Because just because it says this in the contract doesn't mean everybody's aware of the situation. Because
I have a
you've talked
question.
with the lender and the lender has said we're delayed and you've told the listing agent we're delayed, that doesn't mean that the listing agent has necessarily gone and fully informed the seller, and the seller may not be fully aware, and there could be some animosity at the end of things if everyone's not aware. Now, it's not your job to make sure the seller's taken care of. You don't represent the seller. However, it's always good practice to make sure everybody's aware of all the situations within the terms of the contract, and an amendment is the easiest way to do that. When you have an amendment signed by all parties, you are now confirmed that all parties are aware of the situation and in agreement. Okay?
I have a question.
Yes.
When I bought my house, well, long story short, the house had a one of the owners passed away. So a third party had to sign some documents. Long story short, the house had a lien or something, and our contract was expired for 2 weeks. I called the lawyer, the title company, and I said, we need an addendum because, the contract is going to be expired today. And the lawyer says, don't worry about it. You both are you are interested to buy the property. He's interested to sell the property. So we don't need an addendum.
that is very risky, right? Because
Yes, that doesn't fly in Lucy land.
yeah, I was like, what are you talking about? I mean, so right now I have nothing in my hands. And the lawyer said, don't worry about it. Everything is fine. And I was like,
Oh,
that's weird.
yeah, that is weird. I would do an amendment, absolutely amend them. I would get something signed. Because you're out of contract. And if you're
Correct.
out of contract, there is no agreement. There's no meeting of the minds.
Yeah, my fear was somebody else can come and offer more money for my property, and then I have nothing. You know what I mean?
Yes.
That was my fear.
Yes, that's a valid fear. So, okay, does this make sense to everybody? We got initials at the bottom of the page. This page talks about some more choice of settlement agent, things that are kind of covered in the CDIF a little bit more. Deed and title, again, if you have a special circumstance, that is listed here. And if there is a special circumstance, it will be disclosed in the MLS. At the bottom of this page, the buyer, at the buyer's expense, either waives or desires a survey. Now, if the buyer desires a survey and then changes their mind and doesn't get one, that's not a problem. However, if they waive a survey and then change their mind and decide they want to get a survey, you're going to need to get an addendum, all parties agreeing to that survey. So I would say it's better to desire it and then just notify the other side they've changed their mind if they decide not to get it, rather than waiving it and then saying, oh, you know, maybe because now we want to put up fencing and maybe a pool, it's better to have the opportunity than not. Initials at the bottom of the page. Prorations, this is, you're going to check A. A is going to be your default. We're not in a position of doing assumptions. You don't even need to pay attention to that. So A is always going to be checked under number 10. And then this is one of the new sections in the contract in July is talking about HUD/FHA or VA financing and the special circumstances regarding that. And then conventional financing is your other option for financing. If it's cash, you're going to check cash, and then does or does the buyer not wish to order an appraisal? And it sets the parameters for if they do wish to order the appraisal within that time frame. Talks about the appraised value regarding conventional loan and cash. That appraisal for the VA and FHA is handled up in this area because they're a little bit different. Initials at the bottom of the page. Property condition. You're not a home inspector. Don't put yourself in a position of being liable for something. You can use this section to address something like wanting the carpet professionally cleaned before closing or having the home professionally cleaned, or things that are blatantly obvious to the untrained eye as you're in the home. For instance, there's a big hole in the living room wall. You can address that. Hole to be properly patched and painted to match. However, do not go looking for things. That's what the home inspection is for, and that's what the PICRA is for. So only cleaning items or blatantly obvious items that need to be fixed that the buyer notices, and don't go calling them out to the buyer. If the buyer says, hey, I'm not happy with that, I'd like to have that addressed in the contract, that's great. Let's not open a can of worms. Let's leave that all for the home inspector.
Is there any proper verbiage, or are you just flat out just saying what you want to be done to the property?
You're going to want to spell out what it is and how you expect it to be fixed. Like I said,
Okay.
if there's a hole in the living room wall, don't just say repair hole in living room wall. You're going to want to say properly patch and repair the wall and paint to match the existing paint kind of thing. You're gonna want
Fair
to
enough.
have a detailed resolution to what you see as a problem. Otherwise, they're just going to slap a Band-Aid on it and move on. Buyer has or has not physically inspected the property. If they have not physically inspected the property, you must provide the no physical inspection addendum as part of this agreement. Paragraph 13, know it, love it, understand it. This has to do with the seller's responsibility regarding wood destroying insect, moisture, and organisms, or septic and water situations, or appraisal situations. So this amount defaults to 1%. So in the case of our $100,000 contract, this 1% would obligate the seller to $1,000 for repairs for one of those things. If the repairs are more than that $1,000, it becomes a negotiation again. If neither party agrees to pay the excess amount, then you can terminate and the buyer gets their money back. So this could come into play with FHA and VA appraisals more so than conventional. Those appraisers are trained to look for major system malfunctions, fogged windows, roof situations that look suspect. In the case of VA, any steps that are more than 3 steps high must have a handrail. So those will be listed in the appraisal that comes back. And the seller then is obligated to repair those up to the amount of $1,000 in the case of this contract. So 1%. Even if they come back and say, no, this is a 0. Okay, 0%. The buyer is still protected because of this highlighted statement if neither party agrees to pay the excess amount. So if the repairs are only $500 and you've got a 0 in there, guess what? 500 is more than 0. Nobody's willing to pay it. Well, the buyer can terminate and get their money back, their earnest money back. Okay. Definitely know and understand this paragraph. And this has nothing to do with the PICRA request. If you put together a whole other PICRA that's got $5,000 worth of repair items on it, and then here comes the appraisal with these items, or the wood destroying insect and organism reports with items, that's a separate ball of wax that does not fall under those PICRA repairs. And they can't say, well, then we're not doing those PICRA repairs because of this. That doesn't fly. Regarding your wood destroying insect and moisture reports, you're going to decide, does the buyer want to get them at the buyer's expense or the seller's expense, or is the seller going to get them and have the buyer pay for them or the seller pay for them? I don't care how you work this. Typically, people ask for buyer at seller's expense, and the seller's going to come back and say, no, if I'm paying for it, I'm picking. And a lot of times the seller has a contract. So it's going to cost them less to get those reports from the people they're under contract with. It's a negotiation. There's no right or wrong. It's whatever everybody's comfortable with. When you're asking for this, make sure you ask for any items that are not part of the home structure. The deck, the shed, a storage unit, a detached garage. If we're lucky enough, a pool house, a guest house, or any other outbuildings. If you don't list them, they will not be covered by this report. Correct, Jordan. A VA buyer cannot pay for the termite and moisture inspection. So in the case of a VA buyer, it's going to be at seller's expense always. Whether the buyer or seller is the chooser of the company and obtaining the report, the seller must pay for it. It makes a whole lot of sense. This is not required. This is just a suggestion for your timeline for delivery is match your property inspection contingency timeline and have your termite inspection done at the same time as the home inspection, if the buyer's the one doing it. Just causes less invasion on the seller's time, and it's easy to just have everybody out there in the same 3 or 4 hour time frame to get things done if you can. But typical timeline is usually anywhere between 7 and 14 days after ratification. I picked 10 as my round number. And keep in mind that this is the time which these documents must be provided, not when the inspection must take place. So the inspection must be done and the documents must be provided within 10 days after ratification. In my case, if you put 7, if you put 14, whatever, that's your timeline.
So for this one, for a buyer, you would want to see a lower number, but for a seller, I'm assuming, would you want a higher number, or does it not matter?
I don't think it matters.
Because if you're a buyer, okay, because the way I see that is if you're a buyer and there's, say if they ask for 20 days, that's mean I'm gonna be waiting for 20 days for you to accept this offer. And if you don't accept it, that's mean I wasted 20 days. Is that how I'm seeing it, or no?
No. This has nothing to do with the acceptance of the offer. Once the offer is accepted, whoever's getting those inspections must have them turned in within this amount of days.
Within that, okay, so the inspection has to be done within those 10 days.
Yes, after the ratification, after the acceptance of all parties.
Got it.
Okay. Now, you definitely don't want anything. I would definitely not recommend anything longer than 14 days, because I had an agent a few years ago who had a contract that kind of went out far. They were kind of given in to the seller who needed to find a place to live. So they had a 60-day closing. And they didn't have these inspections scheduled to be done they had a 45-day wait in here. Well, guess what? At day 45, here come all these reports with all this work that needs to be done. And now we've only got 15 days till closing. How are we going to guarantee to get this work done when supplies are scarce, workers are scarce, and we need to have this done to close? So the sooner you can have this done with regards to any potential repairs that have to be done, the better. It's in everybody's best interest to get them done sooner rather than later, especially now since we've got a bit of a scarcity with lumber and other materials, as well as certain companies being kind of stretched. Okay. And then if those reports are not delivered within this time frame, the other party can get them done. And then the party that was supposed to have done it in the first place will reimburse the party who ends up doing it, if that's the case. Most letters don't cost more than $100. So $100 in there should be plenty for that reimbursement purpose. Checking the chat here. Everybody good? All right. Looks like we're okay. And then initials at the bottom of the page. Same kind of scenario with the drinking water and septic. Now, unless you've got a buyer who's super duper familiar with the area and the companies in this area who do service wells and septic systems, I would almost always put this at seller's expense, because the seller's been living there, the seller's been dealing with these systems, and the seller probably has a provider that is well versed in how this whole thing works. So that would be my recommendation, unless you've got a really great well person that you're really familiar with and a really great septic person you're familiar with. I would leave this seller at seller's expense for both of these. And then under the septic, I would always, unless the seller's got something in hand that says that the system has been pumped within a reasonable amount of time. I don't know enough about septics to know what a reasonable amount of time is, but I would think 90 to 120 days. If they had it pumped getting ready to go on the market and know that this was going to be a thing, that would be sufficient for me. But if they can't say when, we've lived here for 5 years and we've never had a problem, it's never been pumped, I'm going to ask for it to be pumped. Let's start out with fresh poo, not everybody else's poo.
Yeah, I have a question.
Yes.
This morning we went to this class and this lady was telling us that she bought a house and she has a septic for the toilet and a septic for the kitchen. In that case, do we have an addendum? Do we have to write an addendum in order to add the septic for the kitchen? Am I clear with my question?
You are, but this simply talks about the property being served by septic system. So all septic systems attached to the property should be covered by this.
Okay, perfect.
It's interesting that it's a separate field for both. That may have been a way to get around a waiver. I don't know enough. I do not know enough about septic systems to speak smartly about that, and I don't want to lead you wrong. If you have further questions about that, we'll get an attorney or a septic system person.
Well, it makes sense. It makes sense, that is covered. Both are covered.
Yes, that would be my interpretation.
Thank you.
And then we have the walkthrough inspection. The buyer reserves the right to have the walkthrough. You're going to state that the buyer or the seller shall be responsible for the utilities for this walkthrough. Now, this walkthrough at the end, this is at the end of the deal, right before closing. You're going to take your buyer, you're going to walk through, and we'll go over the form. You're going to go over all the major systems. You're going to make sure the house is primarily in the condition it was in when you wrote the contract, and that all the PICRA repairs have been done. We'll go over that form at the end today. So this is simply stating who's going to provide the utilities. It is typically the seller who is going to provide the utilities for the walkthrough, because the utility transfer should not take place until ownership takes place. Then we come into our contingencies. We've got condominium, and we're going to check as applicable. Is not in a community, is in a resale community. And again, this will all be listed in the MLS. Now, I recommend, the listing agent is required to put the association management information and contact information in the listing now. I recommend you call and confirm this dollar amount with the association. If you've got the wrong dollar amount from an older listing, or the listing agent got the wrong number from the seller, the wrong number there can affect the buyer's ability to purchase the property. If you go into this and you and the lender think this is a $200 a month fee, and it turns out that it's shifted in the last 30 days and nobody updated the listing, that increase in fees could take the buyer out of the ability to purchase this property. So I always recommend you take the time, make the call, confirm with the association what those fees truly are, so that you have the correct information for the buyer and the lender. Initials for the buyer. Again, same thing with the POA, Property Owners Association. You're going to check one or the other, and you're going to call and confirm and put that dollar amount there if it is. Co-op, a lot of agents miss this box because we almost never see it. So make sure this is checked. Is not is going to be your default. Again, it will be listed in the MLS if it is a cooperative. And that's a whole different ball of wax. We'll talk about it individually if you come across that. Here's your property inspection contingency section. The buyer waives or desires an inspection. If they desire an inspection, it states that the property inspection contingency addendum is attached and shall become a part of this agreement. Okay. EFS, this is the stucco, the synthetic stucco stuff. So it's either not applicable or they waive or desire an inspection. Lead-based paint, either not applicable and waive or desire an inspection. And keep in mind that all these inspections are at the buyer's cost. If the buyer chooses to terminate the contract, they will not be reimbursed for these costs in 99% of the cases. Initials at the bottom of the page. Other contingencies. This is where you're going to list if the buyer has a home to sell. So it would be successful settlement of buyer's current property. If you're in a flood zone, it could be subject to buyer obtaining acceptable pricing for flood insurance, because again, the price of flood insurance could put the buyer out of the realm of possibility for being able to afford to purchase the property. And then if it's a bankruptcy, a divorce, or a probate situation, it's contingent on a third-party approval. Your items to convey, you're going to get this as combined from the MLS, all items that are listed in the MLS, plus there may be items that you see while you tour the home that the buyer may say, okay, let's say we've got that lovely pool house and the pool out back, and they want the tiki bar that's out there. Well, you're going to write that in to the additional items. Regardless of whether you write in additional items or not, or you're just going with what's checked up here, I recommend that you add this sentence. Items to convey at no cost to buyer, adding no value to the property. Especially in the time when you add additional items, say that tiki bar or the outdoor fireplace, or say there's a media room and the TVs are really, really well mounted to the wall and the speaker system is built in and or attached to the walls, and the buyer's asking for all that to convey. An underwriter is going to look at that and say, okay, but how much value does that add to the property and what is the buyer paying for it? So we're going to save ourselves the time and effort of having to write an amendment for that underwriter and simply state in the contract that the items convey at no additional cost to the buyer and they add no value to the property. It just saves you a step. I'm all about saving you steps and not having you do more paperwork than you have to, because we all know there's enough paperwork here for all of us. Okay, and then here's where we have our brokerage relationship. Most often, it's going to be number 2, where the listing firm represents the seller and the selling firm represents the buyer. The other we talked about was, let's see, selling firm represents the buyer as their client. Seller is an unrepresented party and has signed that unrepresented party form. This is going to be your FSBO situation. If you've got the buyer and you take your buyer shopping at a for sale by owner, and the for sale by owner is the unrepresented party, this is your checkbox here. And then if Letitia has a listing and Jordan sells it, we are designated agents. We all work for the same brokerage, but each party has their individual representation with designated agents. And in that case, everybody's going to sign a designated agent form, the disclosure of designated agent form. Okay? Any questions? We all good? Awesome. We have aircraft noise zone and accident potential zone disclosure. This again is listed in the MLS. You can also find it on the city maps if you're curious and interested. So you're going to put whatever's listed in the MLS, and that ACU's disclosure form is going to be listed, is going to be attached to the listing in RAIN. And you're going to have that.
And that's that negative number, usually like -65. You just put that in that line.
Correct.
Okay.
Correct. So the crash zone is usually none, and this is usually less than 65, and then I think it's 65 to 70 and 70 to 75 and over 75 are our noise disclosure zones.
Okay.
Agency interest disclosure. This is where you're going to disclose all relationships by blood or marriage. And you're also going to disclose that the buyer has a real estate license from any state. If an entity is purchasing the property, you're going to disclose if agent or family member has any interest in that LLC or corporation. Any relationships on the listing side will be disclosed in the MLS and must be listed here as well. So if you see on the listing that it's owner agent, make sure you write in this that listing agent is the seller of the property. But disclose, 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 always disclose. Then we've got some more stuff that's repeated from the CDIF, initials at the bottom of the page. More CDIF repeat stuff. And initials at the bottom of the page. Just a side note, terms and provisions of paragraph 19 survives settlement for 5 years. So this has to do with dispute resolution and written notice and parties and all this stuff. We don't see this very often, but it's interesting to note that that can all survive for 5 years from the date of this agreement. Your other provisions section is kind of your catch-all for things that don't fit anywhere else. For instance, seller to provide a 1 year from date of closing home warranty of buyer's choosing and not to exceed a certain amount and to be ordered by the selling agent. This is really the verbiage I would like you to use for a home warranty being requested from the buyer or from the seller for the buyer, because if you simply say seller to provide a home warranty for the buyer, guess what you're going to get? You're going to get the watered down, generic, least expensive coverage that the seller can find. So I want you to state that the home warranty is going to be of the buyer's choosing, and you're going to put a dollar amount. We have warranty representatives that are happy to talk to you. Documents are in the office. Get with your fellow agents, find out who they like and what warranties their clients have had really good luck with. Again, since I don't sell, I don't have my finger on the pulse of this information. Talk to your mentors, talk to your fellow agents, and they'll be happy to help you figure out what warranty will work best for your client and this particular property. But we always want to be having our buyer's best interest at heart when we're asking for these kind of things. And then if you're selling a for sale by owner property, this is where the commission to Keller Williams is listed. Remember that all commissions go to the brokerage, not the agent. So you're not going to put in here that, you know, Tammy agent is going to be receiving a 3% commission. It's going to be seller to pay Keller Williams a 3% commission at closing. And that's all the attorney needs for that. You won't be doing a regular brokerage fee agreement on a for sale by owner. Again, your mentors know how to do all this. They're well versed in this stuff. They have the answers and the power. Initials at the bottom of the page. This box, please, 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 before you ratify, make sure both parties have initialed this box. If the buyer and the seller do not initial, digital signatures are not acceptable for use in this transaction. If one of the initials is missing, you're going to get a love note from me that says, great, you're approved. However, all documents going forward must be pen and ink signatures unless you do an amendment stating all of this. So it's just easier before you ratify, make sure this is initialed by all parties. Now I've noted here, initialing does not mandate the use of digital signatures, but allows the use by either party. So say you've got older sellers who are not comfortable with the technology and you meet up with them at Starbucks on a weekly basis to discuss things and have them sign whatever's needed, and they don't want to use digital signatures. That's great. They don't have to. You've worked it out with them. You've got a plan and you know how to handle that. That's perfect. However, what happens if their buyer's coming from California? How are we going to get all those initials in a timely manner if we're not going to agree to digital signatures? So let's make sure everybody has the option of using digital signatures in the transaction, please. Questions? And then the next page, well, we're going to initial that after we've initialed the box. And then we're going to have all this filled out. and signed. And that's the purchase agreement we're going to send over to the other side. But we've got other documents we've got to send with it. So let's continue on our checklist here. I don't see any other questions. All right, we have requested a home inspection. So we're going to have to fill out this form as per the purchase agreement. You're going to match all of this information, needs to be identical to what's at the top of your purchase agreement. You're going to check the box for home inspection and whether the buyer or the seller is going to be responsible for providing the utilities for the inspection. If you've said you desire an EFIS inspection, you're going to check this. If you've checked desire a lead-based paint inspection, you're going to check this. Specific inspections by DPOR licensed contractors or tradesmen, such as an HVAC, a structural engineer, mold, lead, or radon. So these would need to be DPOR licensed inspectors. Other inspections that are not required to be DPOR licensed could be termite, moisture, survey, septic, and any other inspections that the buyer or lender may desire. And that can include a chimney inspection, a pool inspection, a hot tub inspection, and the like. Okay, I recommend that this statement always be included: termite, moisture, survey, septic, and any other inspections that the buyer or lender may desire. Should just be kind of a boilerplate thing you put in here and check this box. Because
go ahead, continue.
well, that just covers the gamut of anything that may come up during the course of the home inspection. It's like, well, we need to get this. I mean, you know, you want termite and moisture. We know it's listed in the other one, but this is just another layer of protection. Does that answer your question? You have something else?
Yep, nope, that pretty much answered. I was going to ask, so pretty much just always have it on your contracts because it's more of a protection. It's more of a protection thing.
Yeah, it's just another layer.
Okay.
And then buyer initials. Okay, paragraph 2. This is important, and this spells out everything that happens within your contingency negotiation period. So your deadline delivery, you're going to write out the days, and like I said, it's typically 10 or 14. Now I'm seeing it being 5 or 7 because sellers are not willing to wait around for these reports to be done. They want to know their property's under contract and move on. So whatever you're comfortable with, hopefully you've got a home inspector you're confident in, and you can call them and say, okay, I'm getting ready to do a contract. What does your schedule look like? If I need you to come out, what are you looking at? And you can go from there and use those days for filling in these blanks. Note that this is calendar days. It's not business days, so it includes weekends and holidays. Take that into account when you're writing in these days. If you go under contract on the Thursday before Labor Day weekend, you might want to really push for that 14-day inspection time frame. Because what if all the inspectors are either booked or out of town or doing last minute stuff, getting their kids ready to go back to school? You need to know that you've got enough time to get the inspection done, get the written report back from the inspector, go over the report with the buyer, find out what the buyer's pain points are and what we're going to ask for regarding repairs, and get that PICRA put together and ready to submit. So all of that has to happen before the end of this number of days that you put in this contract. Okay. So if you get the report and it's got a laundry list of items, including big system items, and the buyer says, I can't, I can't, I just don't want to even ask for anything. It's too much. I'd never be comfortable. At that point, within this 10 to 14 days, if you're not going to ask for anything and the buyer wants out, you're going to do a release and at your option a termination. At that time, you do not provide any of the reports. You simply ask for the release. The buyer is under no obligation to say anything other than it's an unsatisfactory home inspection. I'm requesting a release, and there should be no question.
I
As
have
long
a
as you're,
question.
yes,
Does a new construction requires inspection, home inspection?
I would, depending on where they are in the home build period, I would do a home inspection. You'd need to talk to an inspector, but I would definitely want to do an inspection before drywall, just to make sure that we don't have lumber issues with the studs and the things that are in the walls that could come out and bite us later.
I would advise it because as someone who just did a new construction and closed on his home, when I got my inspection, they found a ton of stuff still, even though it was new construction. So I would still advise your client to still get a home inspection.
Yes,
Yeah.
yes. Always get a home inspection for new construction. They're some of the worst offenders.
Yeah, and Jordan, you're probably more familiar. At what stages? I know I've seen multiple stages of inspections within the home build period. What are your thoughts?
So I always ask for copies of the satisfied inspections from the city inspectors, like the electrical, plumbing, et cetera, et cetera, et cetera. I like to have my inspector come in pre-drywall, like you said. I like to have them come in like right around the same time that we're getting the certificate of occupancy. And that one's kind of like in the middle as far as whether it's needed or not. But I definitely like to have them do it as a final walkthrough. That way we can do a blue tape inspection as well.
Mm-hmm. And yeah, it is a bit of a financial burden on your client, but the peace of mind it offers is just, you can't put a price on that. So absolutely with new construction. Now, let's say you have sat with your buyer, you've gone through the list that the home inspection report comes out with, and you've put the PICRA together. You have to get that, you have to deliver the entire inspection report along with your PICRA to the other side within this time frame. Again, this is not just the time frame to get the inspection done. That is the time frame to get the inspection done, go over it with your buyer, put together your requests, and deliver it to the other side. Once you have delivered it, this comes into play. So understand all of this. So once the buyer delivers it, there are 5 days for the seller to mull it over, negotiate, send back a counter, or agree to all of the items on that removal addendum. If the parties agree to the terms, everybody executes the amendment of the addendum and signs, ratifies it, and we move forward. If it's not, if you're back and forth and back and forth and back and forth, and you just can't come to terms and the buyer's not happy, the buyer can terminate within 1 day following that negotiation period. So you've got the 5 days to negotiate. Then you've got the 1 day, that's day 6. The buyer on day 6 has the right to terminate. The seller can terminate after that additional day if they can't come to an agreement. So no one understand this. I don't think we're finding this happening a whole lot right now. Usually it's a case of the buyer says, I'm just not, and they terminate without submitting a request, and they move forward. So here's the requested repairs requirements. You know, the buyer must list in the removal addendum all the identified items they want the seller to repair. And then you have to provide the full property inspection document. So no one understand the deadlines, negotiation periods, and what is needed if repairs are requested. Initials and signatures. And this is to be submitted with the purchase agreement. This is important. This is your paycheck. Make sure you submit this with your purchase agreement. I had an agent, this has probably been 3 years ago now, who was purchasing the property for themselves and did not submit this form with the purchase agreement.
That's the paycheck.
The listing agent took that to mean that because they were purchasing the home for themselves, they were not requesting a commission. Therefore, that made the deal more beneficial to the seller. So when they broke it down, they had 3 offers, and our agent's offer ended up netting the seller the most money because there was no commission involved. So roll on down a week or 2 into the deal, and the agent calls me in a panic because Lucy, the listing agent says I'm not getting a commission. Well, did you submit the brokerage fee notice? Well, no, I just did. And they're saying no, because I didn't submit it with the offer. And the seller only took my offer because there was no commission attached to my deal.
Well,
Now, that's not any way I ever would have interpreted it, but it's not wrong. It's not an incorrect interpretation. I probably would have asked for clarification before I went forward with that offer, but I can't fault the listing agent for having that interpretation of the offer. Well, we had a very, very, very generous listing agent who went back to her seller, explained the situation, managed to get the seller to come up to a 4% from 3%, and she split it down the middle, and our agent got 2% instead of nothing.
wow.
You cannot count on that kind of generosity from the other side. So regardless of whether you're purchasing a home for yourself or a client, this is your paycheck. Put it in with your offer. So you're gonna have the seller's name from the MLS, the full property address. You're probably not gonna have an under contract date because you're submitting it with the offer. So the date of the offer is fine for me. I've never had anybody argue that. You're gonna put the buyer's names from page 1 of the purchase agreement, the listing firm from the MLS, and Keller Williams Realty and the selling firm. And then it's going to be 3% or whatever is listed in the MLS. Now, let me tell you that part of the reason we want you to have your copy of the MLS printout at time of showing is because that is time and date stamped, and it shows what is offered as a commission. So we've had agents in the past try and go in after the fact and say, oh no, it's only 2.5%. Look at the listing. Well, we can pull out our printout from our showing and our offer time frame that says, no, it was 3%. We're entitled to 3%. And we're able to get you your full commission if we have that documentation. Okay. And know that if you've got that MLS printout with you and you go into a home and it says on that printout 1.5% commission, that's all you're entitled to. You can go to your buyer based on our buyer brokerage agreement and get the other 1.5% from them, or you can agree to accept that 1.5%. You can never, ever go under contract on a property that you showed that had listed a 1.5% commission and say to the listing agent, but I want 3%. The minute you pop that lockbox, you have agreed to whatever commission is listed in the MLS. Just know that, okay? Any questions? Don't leave this off. Don't be lazy. This is important. I want you all to get the money you deserve. Okay. Let's take a quick look at the PICRA just because we've looked at the PICA already. this is the document that you're going to submit after you've done your home inspection and your buyer wants to request repairs. The top part is going to again match the front page of your purchase agreement. You're going to check whatever inspection reports are attached. And then you're going to put either no repairs are necessary, in which case you don't have to do anything other than get it signed, or you're going to check this box and you're going to request your repair items. I would like to see you be very specific in listing what the buyer wants to have repaired. I know a lot of agents simply list the reference to the home inspection report as to what's wrong. And that identifies fully what is wrong, but it does not fully identify what the buyer expects to have happen. And Jordan, feel free to chime in as we go through this. Because
So, yeah, these are very, very tricky. And I like to do both of what Lucy is saying. Whenever I do write a picker, I have a very in-depth conversation with my buyers. Okay, you want this fixed? How do you want it fixed?
yes,
You want it fixed the way the home inspection says it? Cool. I'm going to, or talk to the home inspector, or you've got a contractor friend. How do you want this fixed? And I put in specifically what they want done, why they want it done that way, and the reference for the home inspection. My pickers are not short,
right.
but they are detailed. And because they're not short, they sometimes freak other agents out. So I always call and say, hey, just so you know, it looks long. It's not that bad.
Yeah, and that's exactly how I'd like to see you do it. Is yes, you're absolutely right to reference the specific call outs in the home inspection report, but you can't simply say the toilet in the hall bath is loose. That's a statement. We can all agree to that. Roger that, it's loose. It doesn't say toilet and hall bath is loose and needs to be secured properly and no longer move or whatever, however you want to do it, but it needs to have a remedy attached to it. And if you want a licensed contract, well, I mean, this says, oh, all repairs are to be in a workmanlike manner. If you want a licensed electrician to do something, you need to say licensed electrician to blah, blah, blah. If you want a licensed plumber to handle it. And then you're going to also at the end of all of this state that repairs to be completed, I would say 3 to 5 days prior to closing, and receipts provided.
I always say receipts provided or given to selling agent, that's us, 3 days prior to final walkthrough. And that way I make sure that I have them. And then if they don't get them to me, then they are in breach of contract.
Right. Perfect. Good to have somebody out in the field here helping me out. Thank you, Jordan.
Always.
Initials at the bottom of the page. And then signatures. Now, after we've gone back and forth and lined things out and initialed things and made it all ugly, we're going to ratify it. So this must be ratified after all the parties are in complete agreement and all the requests and everybody's clear on it. Questions? I got something in the chat here. Does the seller have the right to speak to the inspector the buyer selected? Well, sure, because you're going to have to provide the full report. So the inspector's information is going to be there on that report. What the seller does with it at that point is completely up to them. But absolutely, I would say it's not out of the seller's purview to call the inspector and say, I need clarification on this. Explain to me what you mean by this.
As long as he's respectful. I would
Yes.
give that caveat. A lot of my
Yes.
inspectors tell me they get yelled at by sellers often.
Yeah, that's not cool. That's not cool.
That's what I was getting at, because I wasn't sure if some sellers might have a more confrontational approach to the inspector. So that's why I asked that question.
Yeah, so if you're the listing agent, you're definitely going to want to have have some control with your seller. And again, communication is key in this business. If you've had that discussion, if Jordan has called you and said, look, I know this looks scary. It's, 3 pages of stuff, but it's all little stuff that could probably be handled by a handyman. We're just being really thorough in our request. And you can present it that way to the seller. And it brings things down a notch from the get-go. So communication, it's all
I always
communication.
say, as the agent, no matter what side you're on, when you are talking to the agent on the other side, you are giving that agent the script of how to present it to their clients.
That's a
So
good approach.
Understood.
In a way that is respectful, that is compassionate, that is logical, and you make your case because you're giving them their script
Absolutely.
back to the seller or buyer or whoever.
Thank you.
Okay, so now we're into disclosures. These items should be attached to the listing in RAIN. There may be a circumstance where the listing hits live and the disclosure documents aren't quite there. I mean, if you're Johnny on the spot and you and your people have been on the hunt, you're probably catching these things the minute they hit the market, and they're maybe in the process of getting these things loaded. Make sure you get these documents from the listing agent if they are not attached to the listing in RAIN. I think there's a 3 or a 5 day time frame in which they have to be loaded, but especially if it goes in last thing on a Friday, the disclosures may not get in over the weekend. But before you put the offer in, make sure you get these documents from the other agent. There is all kinds of fines, fees, and potential jail time associated, especially with this lead-based paint disclosure, because it's a federal mandate, not a state, city, or Lucy mandate. That if this is signed by the buyer prior to the seller disclosing, I think it's like $20,000 per signature fines associated with it, with potential jail time. So don't do that. This disclosures, sellers disclose, buyers acknowledge. So all disclosures should be filled out and signed by the seller and acknowledged receipt by the buyer. So this will be filled out. It will be in the MLS, or like I said, from the listing agent, already completed by the seller. So you're going to only be responsible for the buyer's information. And the buyer's going to initial A because, or I'm sorry, B, because we have provided this as part of their buyer consultation. This is that EPA booklet that I have you do at the beginning of your consultation. So you know they've seen this. They know the dangers and what happens with potential lead issues in the home. So they're going to initial that they have received that document. And then they have either received the opportunity to inspect or waived the opportunity to inspect. And that's going to be based on those checkboxes in the original purchase agreement. And then everybody's going to sign it. This will already be filled in and signed by the seller. Got a question up here in the chat. Yes, Jordan, this goes for FSBOs as well. When you send the offer, you send these blank for the seller to sign first. Because remember, you don't represent the seller, you only do admin tasks for the seller. So as a party to the transaction, you are okay sending these documents to the seller, but the seller has to fill them out and sign them. And then we have the DPOR. This is the seller's representation of the property. Virginia is a buyer beware state. Therefore, the seller says, yep, it's a house. It's up to you to figure out whether it suits you or has anything that makes you nervous or needs fixing. So this will all be filled in by the owner, and the seller should have the full address and legal description, and then this will be acknowledged by the buyer. Again, if it's a FSBO, you give them the blank form and you make sure they sign and date it before your people, your buyers do it all. And then the same with the ACUs. And a seller's going to say, well, I don't know what noise and crash zone I'm in, for sale by owner. You're going to say, Google ACUs Virginia Beach, Google ACUs Chesapeake, and the maps will pop up. They're interactive maps and they're easy to use. Don't tell the seller what noise and crash zone they're in. They can find it online. Now, this form gets a little confusing, and I don't usually get wrapped too tightly around the correctness of it. This form is required for Virginia Beach, Chesapeake, Norfolk, and Hampton, because all 4 of those cities have military air disclosures, which have active air noise happening. We've had some, I'll say, discussions regarding Hampton, because Langley Air Force Base is in that southern part of Hampton and is so far away from the northern part of Hampton that the people in the northern part of Hampton don't feel that they're required to disclose anything. I've kind of given up the argument. If they say it's a no, I check the map, and if they're far enough away, I typically let it fly. However, Chesapeake, Virginia Beach, and Norfolk, we want the disclosures, because the cities are compact enough and tight enough around these air institutions, these military institutions, that we want this fully disclosed. Okay. So if it's a no, none of this will be filled out. It will just have a signature at the bottom by the owner, and the purchaser just signs. If it's a yes and one of these things is initialed, there is no need to have the buyer initial next to the seller. This is simply being disclosed by the seller. The buyer simply acknowledges that disclosure by signing at the bottom. If the buyer initials at these spots next to the seller's initials, I'm not going to send it back, but it's not necessary. And again, this is going to be in the MLS or gotten from the listing agent, or you're going to give the blank form to a for sale by owner. We good on disclosures? Okay. A couple of other addendums we have to the contract would be for condominiums and property owners associations. Again, this is to be completed by the seller, uploaded into the listing. So these things should be filled out by the seller. It's going to be blank on the spots where I have things filled in here for you. So the seller line will be filled in, the listing firm will be filled in, the property should be filled in, the association information should be filled in, and whether the seller has gotten the package or whether they authorize their agent or their firm to get the package. So all of this will be filled in. You're going to fill in these spots I have filled in for you, the date on the purchase agreement, match the buyer's full names, and then Keller Williams Realty. And then the buyer's going to initial this page, and they're going to fill in this part. Do they want, I don't know that hard copies are even available anymore, honestly. I think it's all going to be electronic format. And then does the buyer authorize you as the agent to receive the information, or do they want it direct to them? If the buyer chooses direct delivery, make sure your email address is included in the delivery information so that you're aware when that is delivered, because there's a timeline attached to this. And that is spelled out. Oh, it's spelled out up here. Yes. Buyer may terminate the agreement within 3 days or up to 7 days if all parties agree, and extend it in writing after the date of the ratification of the agreement if the buyer receives the condominium, blah, 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 all these things. So let's boil it down. The buyer gets the package on Tuesday morning or Tuesday during the day. Their 3-day counter starts at 12:01 a.m. on Wednesday and goes all day Wednesday, all day Thursday, all day Friday, and at 12:01 a.m. Saturday, if they have not terminated the agreement, they no longer have an out. So within those 3 days, the buyer needs to go through the packet and make sure that they're in agreement with all of the rules and regulations of the association.
Also, make sure that if your buyers want it sent directly to them, that you are putting your buyer's information down there as well. If you only put your information, then I'm only sending it to you as the listing agent. And
Right.
I just had that happen, and the buyer's agent got mad at me, and I was like, I don't have your buyer's information, so I sent it to you.
Right. So be very thorough in the way you fill this out. So you're going to put the buyer's name and address and their email address, but you're also going to add yours as a secondary email address. Okay. Now, this is something that's kind of like, you know, the warning labels on things. You don't know you need it until you need it. I have added this. This will not be written on what you get from the seller side. Seller agrees to resolve any and all association violations prior to closing and provide a clearance letter from the association. Well, guess why this is now part of this agreement on my end? It's because we had a situation where a bunch of violations came in. They weren't violations of the sort that the association required them to be done prior to closing, but they were of the sort that any transfer of the property resulted in an obligation to have them completed within 45 days of settlement. So it was things like the door was the wrong color, the shed hadn't been approved by the association, and I can't remember what else. So the buyer really wanted this property. The seller said, well, I'm not under any obligation to do anything about this. You've got 45 days after closing to do it. And we had one heck of a battle. And the buyer finally said, okay, I guess I'm just stuck. I've got to do it all. And because they wanted the property. So we came up with this. And this puts the seller in the hot seat. If any of those violations come back on that information, they have to remedy them and provide the proof of clearance from the association prior to closing. Now, if you add this to the document, you're going to have the buyer initial it because it's an addition to an already signed document, and the seller's going to have to initial it before this is a complete document. Does that make sense? I've only seen this come up that one time, but it was a doozy and it required a warning label.
Thank you.
So this again goes with your purchase agreement. After you get those documents from the listing agent, or your buyer gets those documents from the listing agent, you're going to fill out the acknowledgement of the receipt. And this is more of a notice for all parties when that 3-day counter starts. You're going to fill all of this in to match the top of the agreement. And again, this just describes the timeline that everything starts, and you're going to have this part filled in. If you have been authorized to receive it, you're going to put the date and you're going to sign it. If the buyer is the one receiving, you're going to put the date they received it and their signature. Okay, and B doesn't happen. The non-availability pretty much doesn't happen. We're going to acknowledge the receipt. And this is, as soon as you get that resale package, this needs to be filled out and sent to the listing agent because it alerts them to the start of the 3-day counter. And, you know, as a listing agent, you want to know when you're through those final contingencies and we've got a solid deal to move forward with. So this is kind of that last flaming hoop that we have to get through till we're sure we've got a solid deal. Does So it's the
So-
sooner,
I have a question. I don't know if I understood. This disclosure, does this disclosure has to go with the whole package?
no, this is after you receive all of the information regarding the association, the condominium
it.
resale package.
I got it. Thank you.
Okay. So this is after the fact. This is, and I believe the condo associations and POAs have 14 days to provide the documents. So this is probably not going to happen until day 14 or 15
Thank you.
after ratification. So the Property Owners Association is identical. This is the first one that goes with the contract. It just has a different title and talks about property owners associations rather than condominium associations, as we differentiate them here in Virginia. So it's the same form. Basically, all the same things need to be filled in. All the same situations arise for the POA and the acknowledgement of those documents. Same thing. Okay, are we good on that?
Kind of. There are so many forms I get lost, but yeah, I'm getting familiar.
Understand, understand.
It's too much. But
Find
yeah,
find a friend. You've got your checklist. I've got your checklist for you. They're in the Facebook files as well.
yes,
These are, the mandatory things, the conditional things.
that helps a lot. Yes,
So
thank you.
you've got that. Find a buddy. Practice writing contracts together. Practice, get a friend, say, okay, you're my buyer. Let's pull up this listing. Let's pretend, let's write one. And, I'll be the selling agent, you be the listing agent. Let's go back and forth, practice. The more you practice it, the easier it becomes.
Correct. Thank you.
Should you find yourself in a situation of your buyer wanting to purchase a short sale, short sales need bank approval because it means the seller owes more on the property than the property is worth. And we need to have the bank sign off on the fact that they're going to get less money than they're actually owed. And they usually have a threshold of how low they're willing to go. So that will all be in the listing. This form is an additional addendum that has to go with the contract should your buyer be purchasing a short sale property. This section matches the front of the contract. You're going to use this date. Seller has to provide the buyer with written evidence of the approval from the bank that the short sale has been accepted. This date is going to be a minimum of 35 days out, unless the listing agent lets you know they already have a short sale approval pending approved contract. I have not seen that happen often. The problem with a short sale is the seller has to get a contract. They have to agree to it. It has to all be ratified. And the seller has then a litany of paperwork that has to go with this contract to the bank. It goes into this portal in the bank and it stops at step 1 within the bank. The bank has 10 business days at each step along the way to get their stuff done. So the intake person has 10 business days to look this over and see what's missing and get the information that's missing from the seller. Once they have all the information, they send it to the next line of defense that then has 10 days to go over it. And then it's given to the lien holder who then has 10 days to look over it and decide if they're willing to work with it or send back some other number for negotiation. So you can see how this is going to be 45 days because those 30 days for those 3 people to look at it are business days. You've got the weekends and holidays in between. So let your buyer know that this is a long drawn out process. They need to not have any immediate needs. Most short sales take an average of 90 days to close. So just be aware of that. We could see short sales come into the market with the end of the eviction moratorium. And I don't know how many landlords are in a deficit situation because they haven't been getting rent and they may have had to bump out their loan programs, and we might see short sales come about again here, especially
Hey,
after
one dozen.
what?
I need coffee.
So we could end up in a situation where there are more short sales out there, and you're going to have patient buyers who are willing to, especially if the banks get bogged down by a ton of them, like we did in 2009 and 2010. It was taking 6 to 9 months to close a short sale.
I remember that. And it's the same situation with foreclosures?
No, foreclosures are typically already owned by the bank, and the bank already has a number, and the bank already has a listing agent representing them.
So it's faster.
And it's faster because all of this work behind the scenes has been done to determine what price they'll take.
Got it.
So it typically happens faster. A short sale can drag out. So with regards to that, these timelines, your inspection and appraisal timelines, then shift a little differently than they do with a normal purchase agreement. So for the inspection, you're going to want to wait to do any inspections until the date the seller delivers written evidence of the approval. Because none of the inspections are refundable. So if you do the inspection immediately upon ratification and the bank denies the short sale, your buyer's out that money, period.
Mm-hmm.
Same with the appraisal. You don't want to order the appraisal and pay that $450, $550 for that appraisal to be done, and then have the bank deny the short sale. We're going to take it one step further with this appraisal. We're not only going to wait until after we get the written evidence, we're going to wait until 3 days following the removal of the property inspection contingency. Because guess what? The bank is now involved in all of those repair requests.
Yeah.
Obviously, the seller doesn't have any money to do the repairs, or they wouldn't have themselves in a short sale situation. So the buyer comes in and asks for the repairs. Well, now we have to go back to the bank and make sure the bank's going to allow these repairs. So you don't want to do the appraisal until you know your PICRA has been approved.
But even if the property says for sale as is?
It can say for sale as is. That doesn't mean a buyer can't ask for repairs, ever,
Okay.
ever. All of this as is, where is, seller to do no repairs. Great. We understand where you're coming from. That doesn't mean you can't ask.
Okay.
You can always ask. You can expect the answer to be no.
Yeah.
But you can always ask.
You can also always get an inspection with an as-is sale. That's a very common misconception.
Yes.
Yes, correct. I remember you explained to me that already. Thank you.
So, and again, this spells it out in bold letters. In the event approvals are not obtained, expenses incurred by the buyer will not be reimbursed. So this is all at buyer expense. So you want to protect your buyer to the best of your ability, and we're not going to do any of this stuff until we have a written approval of the sale from the bank. And when we go back to this date, if we come up on, say we put this at 45 days, if we come up on 45 days and we don't have any information from the bank, the buyer can terminate the contract. If they're tired of waiting and they don't want to wait around, they can terminate the contract. If they're not in any hurry, they're living in mom's basement and banking money and really love this cute little place and they're willing to wait it out, great. You can extend. It's going to take an amendment to extend past that 45 days. And again, this is not currently a common situation and scenario. So if you get into this kind of situation, go to your mentor, give me a call. We'll deal with it on a case-by-case basis. Okay?
I personally love short sales, so come to me.
There you go. Jordan's your girl. If the bank is on it, they're not as bad as they need it. When the banks are not on it, it's horrible. All right, this is an amendment / addendum to a purchase agreement. This is your Band-Aid. This fixes all of it. When you come to say, Lucy, I don't know what to do, we're going to do an amendment. It can fix all of it. It can fix misspelled buyer names. It can fix property address situations. It can fix an additional buyer being needed on the loan. Anything that needs to be changed or added to the purchase agreement takes place on this form. And it doesn't need to be full of complicated lawyer level words. We're just going to point blank state what needs to happen. So for example, closing will take place on or before, and you're going to put that date in there. That's what we're going to do to extend a closing because we've had some sort of a delay and all parties are going to sign it. If for some reason something was missed off the body of the purchase agreement, for instance, the escrow agent is missing, we're going to say the escrow agent is Title Alliance, Jones Walker and Lake, Hanger Law, whoever you want. If we mistakenly put Bobby Smith, we're going to put buyer's correct name is Robert J. Smith Jr. I'm your verbiage queen. I love verbiage. I can verbiage anything for you. So it may take me a couple times to noodle it through and get it just right. And very often, if we're on the phone and talking this through, you should be taking notes because I'm not. I'm just spitballing. So if you need verbiage, and we're on the phone talking about it, take notes because I'll say, what did I say there? Do I need to redo that? And we'll get it figured out.
It's
Okay.
true, y'all. I had another agent at another firm compliment me on the verbiage I used on a contract. And I was like, that was my broker. That was my broker.
So we can fix it all as long as all parties are in agreement. We can absolutely figure out what verbiage to use. And then you're going to fill it out at the bottom and have everybody sign it. And I recommend numbering your amendments to keep proper track. So amendment number 1, 2, 3, 4, 5. Hopefully you're not going to need more than 1 or 2, but you never know, things happen. And you can put more than one thing on an amendment. If all of this needs to happen, all of it can be listed on one amendment. You don't have to break it down one for one. So if you get a lot of love notes from Lucy that says this needs to be fixed, this needs to be fixed, this needs to be fixed, you can do it all on one amendment. Okay. I'm pretty impressed with myself. I haven't seen a lot of glaring mistakes in the stuff I have filled in this round. All right, we talked about the walkthrough. This is your final pass through the property before the buyer signs on the dotted line to take ownership. We're going to fill this out. I sound like a broken record. Everything matches the purchase agreement. It all goes together. I like to highlight this. The buyer has inspected the property. So you're not going to do this for the buyer. You are the maestro. You're going to direct the orchestra in all of this. You're going to have the buyers with you. You're going to say, go turn the burners on the stove. Do they all heat up? Is the refrigerator cold? Let's start the dishwasher while we're doing the rest of the stuff and we'll make sure it fills and drains. Buyer B, turn on the disposal. Is the exhaust fan fanning? Does the microwave turn on? You can do a microwave test for 3 seconds and not hurt anything. Is it cool in here? You may not be able to check the central air if it's 29 degrees outside in the middle of January. But we're going to hope that because the heating system's working, the central air is also going to work. But that's, mechanical things break. Sometimes it just happens.
Also advise them to bring their own electrical outlet tester.
Yep.
I always have extras that are brand new in my car. And I say, if you want to use this one, you're welcome to if you did not bring your own.
Yep, because you're going to have them go stick the little thingy in the outlets. You're going to have them run the water, make sure the hot water runs to all the sinks. You're going to open the cabinets and make sure the water's not flowing out under the sinks. This
Flush
is
all the
where
toilets.
flush the toilets, make sure that they fill properly, turn off properly and aren't leaking. And again, you're directing this. You're central and you're sending them point A to point B and they're reporting back and we're checking this off. Any other equipment, systems, appliances that are inspected?
I bought my house and 3 days after the closing,
my water heater got broken. So I had
That
to replace
happens.
it.
Yep, that happens. It happens all the time.
Lucky me.
Yep. Yep. So all of this pertains to those walkthrough items under C. The property was found to be in the same condition as the date of the agreement and no more repairs are necessary. Or these items now need to be repaired. And again, that only pertains to these items or items that should have been in the same condition they were in when you put the property under contract. Then we have the personal property. Remember we asked for the tiki bar and the outdoor fireplace? Well, they forgot and they took them. It was in the contract. So they need to make it right. They either need to throw money at it, bring the items back, or replace them with like in kind.
This is very common with things such as washers and dryers.
Yep. Oh, I forgot. Sure you did.
Or the movers just moved them. Uh-huh.
Yeah.
Yep. So just so you guys know, sorry, Lucy, I'm going to interject just real quick. The script that you use when you're going into your walkthrough is beforehand, you tell them to bring their electrical tester. You bring an extra one, brand new in package. So that way if they test one and they're like, but Jordan gave me a wrong electrical tester. No, Jordan told you to get your own. And then you opened a brand new one. You tell them, you walk in and you say, all right, guys, this is not a time to find new issues. This is a time to make sure that all of these things on this checklist work and are the way that they need to be, and that the house is in substantially the same condition as it was when we first saw it during the home inspection, and to make sure that any repairs that we requested for the home inspection have been completed. Those are the only things that we are looking for during this. If there's anything else that comes up, depending on how substantial it is what we're going to have to start addressing if there's anything substantial. I've had where, oh gosh, what was a little one? A piece of furniture was hiding where baseboard wasn't the way that it wasn't finished. Like the baseboard wasn't finished and a piece of furniture was hiding it. And my buyers wanted that fixed. That is not substantial. It is cosmetic because the baseboards weren't painted.
Another common one is buyers are often surprised when they walk in and there's a bunch of little picture holes in the walls.
Or the house isn't cleaned and you didn't ask for it to be cleaned.
Right. All that the contract requires is that it be free of debris and in broom clean condition. That is all that is required per the contract. So then this last section has to do with your PICRA repairs. So make sure you've got a copy of your home inspection report and your PICRA report and all your receipts so that you can compare and verify that those things are done. And then this section is where you list anything that is not done there. Now, if you come up with issues, you are going to have to get a seller signature on this form. The seller has to acknowledge this, because then the buyer is going to sign off on the fact that all of these above items have been completed to their satisfaction. If you have a no repairs needed, as a C little I walkthrough that you send over to the other side, 6 times out of 10, the listing agent's going to say thanks and move on. So you just need to let me know in the comments in Brokerment that you have submitted this walkthrough to the other side for signature. If we get it back, I'll ask that you load it up and resubmit it. If not, we'll move on smartly, because it's hard to get a seller to sign off on this if nobody needs anything done. But the only way to guarantee this stuff is going to be addressed properly is to get seller signatures. So you really need to stand firm on getting seller signature if you have any repair issues that have to be corrected. Okay. And the dreaded release, we hope you don't have to do this. but it happens for a multitude of reasons. This is your release agreement. Most common is that home inspection is just too many items. The buyer just can't be comfortable. They can't be confident that these can be properly repaired, and they need to move on to something that's more comfortable for them. Again, purchase agreement copy.
What happened if the seller doesn't want to sign this last agreement, the release agreement?
They really don't have a choice because it's stated in the contract that it's the buyer's right. As long as you're within your timelines with regards to the home inspection and or the property association or condo association documents, as long as you're within those timelines, the seller has already agreed in the body of the contract to the release.
Okay.
This is just the final.
I was gonna say, that being said, the seller can also hold it up and hold the money in escrow until
Sure.
this is signed. And that's why we get good attorneys like Jones, Walker, and Lake.
Correct.
Or wait for the contract to expire.
No,
No.
there's a whole different level of stuff that has to happen. If the seller doesn't sign this,
Okay.
it then becomes a situation where this is the release of the earnest money attached to the contract. So
Right.
if the seller doesn't sign it, this is the buyer's earnest money that's held up.
Yes, you're
And
right.
so, you know, I haven't seen it come to blows a whole lot, especially if the buyer's not in default. I mean, we've had issues where a buyer decided after all the contingencies were over, they wanted out of the contract. And the seller said, I'll release you, but I'm keeping the earnest money. And the buyer's like, fine, I want out bad enough that I'm willing to give up my earnest money. Everybody signs it and agrees to it. It's just a distribution of the earnest money that becomes an issue.
Yeah, I was under contract in Key Largo, Florida for a property. Long story short, the seller and I got into an argument, and I told her, if you're not going to fix this problem, then keep your house, keep your property. I don't want it anymore. And she told me, then the deposit is mine. So I had to pay a lawyer in order to get my money back.
Okay, well, see, especially if you've put the contract with one of our attorneys, that's all taken care of for you.
Mm-hmm.
Yeah, that's why we've got fantastic people who have our back.
Yeah.
And they're the ones holding the earnest money, so they have no emotional involvement or entanglement in the property or the contract. They're looking strictly at contract law and the rights and obligations of each party and dispersing the money according to that. There's no hurt feelings on their part, which is a really good thing. So this has a lot of redundancy in filling things out, but you need to put the total earnest money amount here, held by the escrow agent here, the earnest money amount again here, because this is the total amount of the deposit. The deposit for disbursement is going to be all of it. We're going to disperse it to, you're going to put the buyer's name and the earnest money amount again. And you're going to check the buyer here. And then you're going to put one of these situations for the buyer. Are they going to have the earnest money in a check mailed to their current address? Are there instructions that the buyer will pick up a check? Is it going to continue to be held by the escrow agent for a future purchase? That has to be in writing because these escrow accounts are carefully monitored, and there has to be a paper trail if 123 Main Street terminates and the escrow that was originally written for that then transfers over to ABC Shadow Road, then they have to have a paper trail showing how that's going to go. So again, we hope you don't have to do this. If you do, we're happy to help you fill it out and get it put so that you're good to go. Termination is an optional form. The release is what handles the earnest money distribution. This is just a formal termination. I would not use it without a fully executed release, because if you terminate a contract with no agreement as to the disbursement of the earnest money, you can end up in a fight. So it's okay to send this with the release agreement, but I would not send this without a release agreement. And it just states why you're terminating. And it would be pursuant to paragraph blah of the PICA, or pursuant to paragraph blah of the POA 1 or Conres 1. Okay. All right. That pretty well covers everything. I know it's a lot. It's so much. And until you do it 3, 5, 7 times, it's not going to be easy. It's not going to be quick. But you will get used to it. It will get easier, and you'll be faster at it. Any other questions, concerns, comments? Jordan, anything else to chime in?
No, you do a wonderful and beautiful job as always, Miss Lucy.
Thank you. So don't forget, all of these forms, just like I showed them to you here in the class, are filled out in red, and all those pretty things are all that's filled out for you in the files section of Facebook. Download them, print them, save them to your desktop, have them available as your cheat sheets to use as you fill things out. It'll help.
I
Okay.
think the only thing I will say is that there are even more documents. Like, believe it or not, Lucy went over a ton of documents. These are the most commonly used ones. There are even more. And if you need anything specific, go to your mentor.
Yeah,
And if you have a mentor, go to Lucy.
There's very often special circumstances, and you know, if you run into a weird situation, we'll figure it out. It may take a couple of heads, but we'll figure it out.
We always do.
Yep. Okay. Thank you, everybody, for attending. I appreciate the time and attention and good questions. And let me know if you need anything. Go out there and sell lots of things.
Thank you.
Thanks, everybody.